Appeals in the matter of Lee and another and BDB Pitmans LLP and another and Adcamp LLP and another and Office Properties PL Ltd. And
Yes, Mr. Carpenter.
Good morning, my lord. Good morning, my lords. The remainder of my submissions this morning will address the 2 points that are deployed in my learned friend Mr. Carpenter's skeleton argument in support of his appeal. And those 2 points can be subdivided in the following way. One, the meaning of the phrase cannot properly be carried on in Rule 19.6, and the meaning of the phrase cannot be maintained in section 35.6b. And those are the submissions that my learned friend addresses at paras 39 to 41 of his skeleton. The second point is as to the meaning of the phrase same claim, as identified by Mr. Justice Leggett as he then was. And those are the submissions advanced by my learned friend at paras 42 onwards of his skeleton argument. And my lords, in the course of my submissions this morning, I will endeavour to address, so far as I haven't already addressed them, the various hypotheticals posed by my lords yesterday, both to myself and my learned friends, and other points that arose in the course of argument. So I proceed straight to the first point advanced by my learned friend Mr. Carpenter, and that is, to repeat, the meaning of the phrase properly carried on or cannot be maintained. Those are the 2 phrases that we find in the rule and the section. Now, at first instance, and indeed in his skeleton argument for this appeal, the case that was put by Mr. Carpenter, my learned friend, was that those 2 phrases, the phrases I've just quoted, extended only to quote from his skeleton argument, constitutional or procedural issues with the claim, end quotes. And that's taken from paragraph 39 of my friend's skeleton argument. Now, in oral submissions yesterday, it appeared that my learned friend's case may have shifted. It appeared that he was ceasing to advance a case about the types of circumstances included within the rule, and that he had jettisoned the test that he'd proposed at para 39 of his skeleton, and instead it seemed that he was expressing a case about what the words of the rule and the statute excluded. And I think the point was put best by my Lord Justice Singh in seeking to encapsulate the way the case was now being put, which was, and I hope I quote my Lord correctly, that the appellant's case is that the rule does not extend to claims that, as originally formulated, will fail on their merits. Now, I wish to address that new case, if new case it be, straight head on. And my lords, it involves simply going first to the decision of this court in Parkinson, which your lordships have been shown yesterday, and demonstrating to your lordships that if we look at Parkinson, as we will do immediately, it is patent that this court has decided that that proposition is erroneous, and that the rule does extend to claims as originally advanced, which will fail on their merits. My lords, can we go to Parkinson straight away? That's the authorities bundle, and straight to page 227. It starts at 225 behind tab 15 if your lordships have tabs. And to remind the court, in Parkinson, the company had brought the claim against the administrators, and it was a common law claim for damages for negligence, in negligence. And we see that at paragraph 3, my lords, 227, where the original claim as brought is described by my Lord Justice Lloyd. And what happened, the claim having been issued and served, is that the defendants then, in their defence, served, as your lordship will see in paragraph 3, on a given date, they pleaded, amongst other matters, that the claim was barred by the effect of the statutory release under Section 20 of the Insolvency Act. That was one of the defences that was pleaded by the administrators. Now, what that demonstrates, my lords, is that the claim was not constitutionally ill-founded. The company had suffered loss, and it was seeking to obtain a remedy for that loss in the tort of negligence, as we see at paragraph 3. The reason the substitution was sought was not because of some constitutional or locus defect in the defendant, in the claimant. It was simply because there was available to the defendant a substantive defence, i.e. it could rely upon Section 20. And my lords, one can see that if one then turns to another paragraph, which your lordships were shown yesterday, paragraph 28, page 233. And if we go about 6 or 7 lines down in paragraph 28, we can see that Lord Justice Lloyd says, I think it's the 3rd sentence, without that substitution, it could only and would be bound to be determined in favour of the defendants because of the Section 20 defence. The claim would be struck out because of that defence, and it could not be decided on its merits, i.e. on its substantive merits, as to whether or not the administrators had indeed been negligent in their performance of their duties and had indeed inflicted loss upon the company. And my lords, one need only pause at that sentence, the one I've just read out, and one can simply replace, for the words because of the Section 20 defence, transposing it to our cases today, with the words the no transfer of liabilities defence, i.e. your lordships could well say and properly say today, without the substitution sought in both cases, in my case on the hypothetical, the court would be bound, the case would be bound to be determined in favour of the defendants because of the no transfer of liabilities defence. Exactly the same situation pertains. So Parkinson, it is clear from Parkinson that the proposition, whether advanced in my learned friend Skeleton or as altered in his oral submissions, is wrong, i.e. the applicability and availability of the power to substitute is not confined to scenarios which do not involve the substantive merits of the original claim being defective. And my lords, if one goes to...
Before you move on,
yes,
in the middle of paragraph 28,
yes,
can you just help me with what is the significance of some words in a subclause? It's the sentence which begins, the claim would be struck out because of that defence. But then there are these words, and it could not be decided on its merits, either way, as the proceedings stand.
well,
What's being got at there?
what's being got out there is that essentially what the court is envisaging or contemplating in Parkinson is a case where the company has advanced a cause of action in negligence. It has no doubt pleaded a variety of particulars of negligence as against the administrators, and has pleaded that those acts of negligence have caused it loss. Those are the allegations which the claimant seeks to be determined by the court. The defendant comes along, pleads its defence, and one of the defences it pleads is, which is a substantive defence, not going to locus, simply going to whether or not the defendant is liable. I have a release, I can rely upon a statutory release as created by Section 20 of the Insolvency Act. Now, that release means that essentially the defendants can, whether by way of a strikeout application or simply by way of running the point at trial, can say, well, that obviates and prevents the court from determining the claim on its merits, i.e. by reference to the actual acts said to constitute negligence which caused the claimant loss. So those words, and my lord is right to alight upon them, support my case, I respectfully suggest. Because just as here, in both cases, whether actually or hypothetically, if we go to trial and Mr. Lawrence advances all his allegations of negligence, the defendant, as currently pleaded, i.e. BDB Pitmans, will say, well, it's all very well that you say this negligence was perpetrated or that negligence was perpetrated. I've got an absolute defence, which is that I am not the responsible party. So that's all very well. So precisely as in that case, precisely as in this case, the claim cannot be decided on its merits. My lords, the point becomes even clearer if we turn to the next in the clutch of cases decided by Lord Justice Lloyd and of course others. We go to Irwin, tab 17, page 277. Now that was, as my learned friend Mr. Carpenter put it, I think yesterday, the mirror image of the Parkinson case. Now, counsel in that case sought to make some distinction between a claim which was unsustainable because of an absolute defence available to the defendant, as against a claim that was unsustainable because of some locus difficulty with the claimant. And oddly, the defendant in that case was making the precisely opposite submission that my learned friend Mr. Carpenter seeks to make today. But what is clear, and what is helpful to this court, is that the Court of Appeal in that case was not interested in those kind of distinctions. And we see that first at paragraph 10, my lords, page 281. Where my Lord Justice Lloyd says the distinction between this case and that is a reference to Parkinson, is that in that case, i.e. Parkinson, the company had a claim against the defendants, so no locus problems, but the problem was the defendants had a complete defence to it, just as BDB Pitmans have a complete defence to Mr. Lawrence's claim. Whereas here, Mr. Irwin does not have a relevant claim against the directors because section 212 does not give him the necessary locus standi to bring it. So the distinction is drawn at paragraph 10, but it's a distinction that doesn't attract the court in any way. See paragraph 15 and then paragraph 26. We go to paragraph 15 first. If I can just allow the court to just glance at that. And in particular, 6 lines down, he sought to distinguish that, as in the Parkinson case, because in that case, the original claim was valid. So no locus standi problem, no constitutional problem, though subject to a complete defence. So, i.e., in Parkinson, the problem was the claim was unable, as originally advanced, to be tried on its merits because there was this Section 20 defence available to the defendants, just as here, as I say. And I can just finally go perhaps to paragraph 26, where, page 284, where Lord Justice Lloyd quotes from paragraph 28 of Parkinson, which we've just looked at, and then says at para 26, here the original claim was liably struck out, as it has indeed been, because of a lack of standing. Takes us back to my learned friend's submission in his skeleton argument, and below. And then we pick up the quotation. But I see no good reason to regard the reason for the striking out as being a critical distinction between that case and this. And your lordships can perhaps read on. And of course you read this passage by my learned friend yesterday. So my lords, we say in 2 authorities decided in this court, the proposition as now advanced, or indeed as previously advanced, that the cases where the original claim is liable to fail on the merits. The proposition that that scenario is out with the relevant subparagraph is wrong. And indeed, it is implicit, not implicit, explicit in the formulation of the test in Insight Group. Let's go straight to it very quickly. Para 96, Bundle of Authorities, page 332. Back to that paragraph 96, and your lordships will recall from my submissions yesterday that the position is that my learned friend necessarily has to quibble, well, not just quibble, has to say that stage one of Mr. Justice Legate's decision or formulation of the test is necessarily wrong, because there Mr. Justice Legate formulated as stage one a scenario where the original claim is not sustainable. And my learned friend has to say that's wrong. We're on stage one at the moment. We're going to come back to stage two of Mr. Justice Legate's test, because my learned friend says it's right, but misapplied by Mr. Justice Legate himself 2 paragraphs later, as I said yesterday. My lords, so in mini conclusion on this point, it has been decided by this court, twice in the Court of Appeal and also at first instance, that the rule extends to a claim that, quotes, cannot properly be carried on due to a defence available to the defendant. And my lords, that proposition is fortified, we respectfully say, if we go to the decision of Mr. Justice Morton in the Ellinger case, where your lordships will recall the words properly brought were being considered by the court in the context of the necessary and proper party gateway. I don't think I need to take your lordships to that very well-known decision, but your lordships will recall that there the learned judge held that the phrase properly brought, of course it's not precisely the same wording, but we've done on our side of the court a good deal of research into how often the phrase properly in the context of a claim that's being brought or carried on have been interpreted by the courts, and this is the best case we could come up with. And what is notable is that when construing the phrase properly brought, which of course is not a phrase we find now in the CPR, but it was a phrase that was there in the RSC for many, many years, and it was held that the phrase properly brought imported an obligation on the part of the court when considering the exercise of its discretion under the necessary and proper party gateway to direct attention to the merits of the claim. And my lords, we handed up to your lordships yesterday the decision of the Privy Council in Ultimo, or AK Investment. And the reason that's relevant is because the rules for service out in the Isle of Man, and indeed for other common law jurisdictions, albeit not in the CPR now, still contain broadly similar wording and are parasitical on that old RSC wording in Order 11. And there, at paragraph 64 to 65 and paragraph 80, I don't take your lordships to it now for want of time, make clear again that the phrase properly brought is a phrase which imports an obligation to consider the merits of the claim against the anchor defendant. And indeed, even more interestingly, his lordship decided at paragraph 65 that the word properly didn't actually add anything to the word brought simpliciter. It didn't somehow affect the merits analysis at all. So, having shown the court that the language of sub-rule B in Rule 19 includes a case in which the claim has been brought, that has in fact been brought, the original claim, will fail on the merits. That then raises 2 further sub-questions.
I really have a problem with all assertions, that's what they show. My understanding of Parkinson and Irwin is in both cases, the company had a claim on merits, or misfeasance, or and the problem was the company's claim couldn't be brought in the name of the actual claimant. And done was substituting a party for whom whose name claim could be brought.
Not so, my lord, with respect. In Parkinson, no one suggested that the company was simply couldn't get out of the stocks. The claim was brought. All that happened was that the defendant pleaded a substantive defence, which happened to be a defence founded in a statute rather than under some common law rule or under some other provision. It was to use the words of Lord Justice Lloyd, it was a valid claim, but was liable to be dismissed because of the plea of.
To the merits.
Forgive me.
It didn't go to the merits.
Well,
That's what you said.
what I invite the court. I just ask rhetorically: what is the distinction between defence 1 in Parkinson, which is paragraph X of the defence, and in any event we are not liable because we can plead sections 20, and we do plead and rely upon section 20 of the Insolvency Act, which gives me a release, statutory release after a period of time, which I can avail myself of. What's the difference between that defence and the defence that will be, just go to the easier claim, which is Mr. Lawrence's case, the defence that will or will not be served at some point or other, whereby BDB Pitmans plead at paragraph X of their defence. And by the way, we are not liable for all the acts of negligence that you've alleged because we are a different part. We're a different party, and we haven't assumed or had transferred to us in any way liability for the torts that you allege were perpetrated by Pitmans LLP. There is conceptually no distinction between those two defences, in my respectful submission.
What you can say is that, I mean, there may be some confusion here about what's meant by merits. They are substantive defences in both cases. That's your point, really, isn't it? They're not matters of procedure or standing. They are substantive defences to the claim.
And critically, in Irwin, Lord Justice Lloyd was distinguished between a substantive defence to a valid claim and a point that went to the very root of the locus of the claimant to issue, because administrators, as your lordship well knows, of course, administrators are out with section 212. But he made the distinction, but said it was an irrelevant one. That's the point, with respect.
I understand all of that, Mr. Grant, but it may be helpful if we go back to paragraph 96 of Mr. Justice Leggett's judgment.
Yes.
At the moment, I think you're addressing the first of the two.
Precisely so.
Yeah. The judge there says that the two decisions of the Court of Appeal are authority for the proposition the claim made in the origination is not sustainable by or against the existing party. Well, it being said that actually what they're authority for is where it's not sustainable by the existing party. They don't actually deal with what happens against the existing.
That is entirely correct in the sense of they are both claimant cases. But I'm sorry.
Forgive me. And could it be said that there is a material distinction between by or against an existing party because a defendant, other things being equal, has the defence in the Limitation Act. And so every time a court says, no, we are going to permit a substituted defendant, it's departing from that rule which is in legislation, and as Lord Scott said in Howard's, that's where the legislature has sought to, or has decided to, strike the balance, not giving a discretion to a court. Does that matter?
It doesn't matter. And your lordship's question engages a wider point, which I'll immediately address, although I was going to address it at a later stage in my submissions, because it engages, in one sense, a question about stage 2 of Mr. Justice Leggett's test as well. The answers are twofold. One, there is not some special rule particular to claimants, which is not particular to defendants, and that's clear from the statute and the rule, which creates a power of substitution indistinguishable between claimants and defendants. The rule, the statute and the rule does not say, and there's a special rule for claimants which is not available to defendants. The rule is cast as a single rule available to substitution of claimants and defendants. And the second answer, which trespasses onto my learned friend's second same claim point, which I might as well immediately address now, is that the section and the rule envisage a scenario where the court has power, or rather invests the court with jurisdiction to substitute, after the lapse of the Limitation Act, D1 for D2, i.e. a claimant has sued D1 and it wishes to seek a substitution whereby D1 disappears and D2 comes in D1's place. Now, I'm conscious I'm moving forward, but I'm answering your Lordship's question, I hope. My learned friend's submission, which is a radical one, but one he was candid about, essentially it means that on his interpretation of the phrase same claim, that can never happen. Because he says the substitution has to be necessary for the maintenance of the claim against D1. But that makes no sense, because the rule envisages and the section envisages a scenario where D1 disappears and is replaced entirely by D2, whereas he, and he's very candid about this in paragraphs 45 and 52 of his skeleton argument, says that the only situation where the power can be exercised is where every fact that you've pleaded to make D1 liable is replicated in the substituted claim, in the second iteration of the claim. Now, of course, that can never be envisaged in any scenario, because necessarily, if the original claim involves a series of facts pleaded to make D1 liable, if you're going to replace D1 with D2, you're necessarily going to change at least some of the facts, because every claim is going to have every original claim will have to say, and the reason D1 is liable is X. But the rule and the section expressly envisage a scenario where D1 falls away and D2 comes in its place. And that's why the test, as it's adumbrated and worked out by Mr. Justice Leggett at paras 96 to 98 of Insight, are, in my respectful submission, correct. I'm going ahead of myself. Would it be convenient if I just went back to I'm just conscious, I hope I've answered Lordship's question.
I'm very keen that you should have the opportunity to present your submissions as you think fit.
Thank you, my Lord. Thank you. So going back to my submission on my learned friend's point 1, I said that two sub-issues then arose. Sub-issue 1 is whether the words in the rule cannot properly be carried on mean only that the claim is liable to be struck out, or whether they extend to a case where, in the event the claim fails at trial, so as to permit substitution after trial. The second sub-issue that arises is if the words cannot properly be carried on mean only that the claim is liable to be struck out, as opposed to be dismissed at trial, whether preliminary or otherwise, whether a party can simply abandon allegations or consent to their being struck out so as to bring themselves within the jurisdiction of the court. And those questions or those sub-issues arise because either way, either of those two potential routes indicates a route by which this court might exercise jurisdiction to order substitution in the Lee case. Now, let me turn to the first sub-issue here, which is whether the phrase cannot properly be carried on mean a case that is liable to be struck out or a case that is liable to fail at trial. Now, Parkinson was a case in which the claim was liable to be struck out because there was a clear statutory defence available to the defendant, which didn't involve an investigation of the facts. That is true. But we say that that sub-rule B in the rule 19.6 is not limited to such a case. So we say that for essentially two reasons. First is that there could be no principled basis for confining sub-rule B to cases which are liable to fail according to a particular merits threshold. Why, I say rhetorically, would the legislature or the Rules Committee draw a distinction between two types of claim? One that is liable to be struck out on it because of the availability of a clear and distinct defence to the defendant, or one which is potentially going to fail at trial after an investigation into certain facts. Why should substitution be available in the first claim, but not the second? Because that would, if that were the case, it would perversely punish or disadvantage the claimant whose original claim had greater prospects of success against the original defendant, as opposed to the claimant whose original claim was really very bad indeed and liable to be struck out. Why, I ask, should the claimant whose claim against the original defendant has some potential of success be in a worse position than the claimant whose claim is really so bad that it's liable to be struck out? And of course, that takes us to the facts of this case, of my appeal, which I made some submissions on yesterday. If, on one scenario, when the application was made by my learned friend's clients to strike out my claim, if my clients had consented to that, to their claim being struck out against BDB Pitmans, then subject to their cross-application for substitution, they would be flatly within the procedural scenario being considered in Parkinson. I brought a claim, defence has been served. One of the defences is we, the defendants, have a slam dunk substantive defence under Section 20. It would be a very odd and perverse outcome if the claimant who has at least some basis for proceeding against the original defendant is in a worse position than the claimant who really has completely messed up its original claim and simply brought a claim against, for instance, in my learned friend Mr Lawrence's case, the wrong defendant without any suggestion by him or by them, his clients, otherwise. The second answer, the second submission as to this scenario is that confining the rule or the applicability of the rule to claims that are liable to be struck out ignores the fact that substitution or addition could be ordered and has been ordered after trial. And indeed, in two decisions of this court, the court has ordered a substitution or a joinder after trial. And your lordships will recall Merritt and Babb, which I think your lordships were shown yesterday, which proceeded to trial where there was only one claimant. There, the daughter was claiming for the full amount of the loss. Of course, she was the house or the property was actually co-owned with her mother, and the joinder of the mother was permitted after trial to allow full recovery of the loss caused by the negligence. And indeed, in a decision by Lord Justice Coulson in Tendring and Ling, which is in your lordship's bundle, we have a scenario where the Lord Justice ordered the joinder of a second defendant after the proceedings at first instance. And here, let's go straight back to our case. If the questions of estoppel, acknowledgement and novation are to be tried as preliminary issues, which I should say was precisely envisaged by the parties at first instance and indeed by the judge at first instance, as I will show you instantly, if those questions can be, and let's say they are tried as preliminary issues, and if it happened that my client failed in its reliance on estoppel acknowledgement and novation, why could not substitution then be ordered to allow the actual claim, i.e. loss deriving from a breach of duty owed by Pitmans, to be determined? Because in the scenario envisaged by the parties at first instance and endorsed by the judge below, we have a preliminary issue trial in a few months' time. Let's assume on this scenario the claimants lose on their reliance on those doctrines. Then the court would have decided that the claim against the current defendant, BDB Pitmans, cannot be and could not be properly carried on, and hence the phrasing of the declaration, which was a contingent declaration, which would arise in the circumstances envisaged by it. And just very briefly, if I can just show the court what the judge herself said in her supplemental judgment when considering the terms of the declaration to be granted. It's page 88 of the core bundle. This is a supplemental, three-page supplemental judgment dealing with questions of permission to appeal costs and the form of declaration. We need only look at the paragraphs under the heading form of declaration, where your lordships will see paragraph 3, last 3 or 4 lines. At the hearing before me, it was contemplated that there should be a preliminary trial of the novation estoppel acknowledgement issues, and the claimant would surely wish the declaration as to substitution to take effect at that point if they were to lose on those issues. There is no reason at all why, assuming I am right about the meaning of the section and the rule, that could not happen. So that's my submissions on the first consequential question, i.e., does the phrase "cannot be carried on at trial" mean only that it can't be carried on, cannot properly be carried on mean only is liable to be struck out, or is it, can it also mean is liable to fail at trial? The second consequential question that I had posed a little earlier relates to the voluntary abandonment of the allegation against the original defendant, or consenting to its being struck out. And let me just formulate the question again. If substitution, if I'm wrong, and substitution can only be ordered where the original claim is liable to be struck out or have summary judgment against it, and I've already said that just can't, it's not a valid distinction, it's not a coherent or rational distinction. But if I'm wrong on that, whether a claimant can voluntarily abandon its allegations as against the original defendant, or consent to their striking out so that the pleaded claim will fail through abandonment or consent. To bring us back to the facts of this case, let's say when my learned friend issued his strikeout application, his summary judgment application, back in September of 2024, before the hearing, of course, before Ms. Shea, we say, hands up, we accept we're not going to be able to pin the liability on BDB Pitmans, and we consent to the strikeout, subject only to our summary judgment, our cross-application for substitution. Now, the authorities suggest that a claimant can bring itself within, if I'm wrong on point 1, within the rule by abandoning its claim against the original defendant. And we can see that if I think your lordships may have back in the authorities bundle, page 332 open. We can see that from paragraph 98 of Mr. Justice Legate's decision, where on the hypothesis he is posing, about 5 or 6 lines down, para 98, 332, sorry, 6 lines down, if I had accepted that analysis of the claims, that is the analysis which pertains in both Mr. Lawrence's and my cases, then I would have also agreed with Master Fontaine that the requirements of little b were met in this case. That is because if the original claims had asserted negligence in the provision of professional services by the firm, they would have been the same claims as those that are now pursued. The only difference would have been that the claimants were no longer contending that the LLP was liable in law for the acts alleged. Substituting the firm, because that was a firm transferring into an LLP case rather than an LLP transferring into another LLP case. Going back to the quotation, substituting the firm because that contention was abandoned would seem to be equivalent in its effects to the substitution of the liquidator for the company in the Parkinson engineering case and then also in the Irwin case. So,
Mr. Grant, sorry to interrupt your flow, but if we focus on that sentence, speaking for myself at least, it seems to me that one of the issues this court is going to have to determine in the present appeals is whether Mr. Justice Lega was right there to draw that equivalence.
I accept that. I accept that, and I, as your lordships will know, very much urge that his lordship was right in both in his adumbration of the test at paragraph 96 and indeed in his application of the test. Because if his application of the test at paragraph 98 is right, then it necessarily follows that these appeals should be dismissed. But one sees there an example of the court envisaging a scenario where a claimant has proceeded against D1, realizes that the claim is a bad one against D1 because in fact the negligence was perpetrated by the predecessor partnership, abandons the claim against D1, subject to its application for substitution to bring in D2. And another example of that, which I won't take your lordships to, is Master Teveson's decision in Collingwood, where certain paragraphs in the particulars claim which sought to fix liability on D1 were voluntarily dismissed and struck through in order to reconstitute the claim as a claim against D2, the defendant who's brought in place of D1. Now, let me just briefly turn to a point raised by my Lord Justice Phillips yesterday, which was a reference to Roberts and Gill. Just dealing with Roberts and Gill compendiously, so I don't have to deal with it any more. That case literally has nothing to tell us as to the disposition of the appeal in this case. And this involves me trespassing a little on the second point raised by Mr. Carpenter, but I might as well deal in one go. There are two submissions, essentially, that need to be made about Roberts and Gill. The first is, the reason it says nothing to us about the disposition of the appeals in this case is because there, Mr. Roberts brought a claim in his own right as a beneficiary under the will against the solicitors. That claim was always going to fail because of a duty of care problem. The solicitors to the estate owed no duty to the beneficiaries. Of course, they did owe a duty to the administrators of the estate. So what he tried to do was to reconstitute the claim as a claim brought by the administrators, albeit by him behind the scenes derivatively, to try and save the claim. And that failed entirely because, of course, a claim brought by the administrators, which in form it would be, even though it was Mr. Roberts who was promoting it via the derivative route, would be an entirely different claim based on a different retainer and based on a different duty of care, i.e. Claim 1 involved the assertion of a duty of care owed directly to Mr. Roberts qua beneficiary. That was going to fail, White and Jones, all the rest of it. So he tries to reconstitute it, but as a claim brought essentially by the administrators, founded on the allegation of a duty of care owed to the administrators. So an entirely different duty and no doubt a different damages analysis as well. So that's the first point, which just takes that case entirely out with the circumference of our claim. But the other point, the constitutional point, takes us back to paragraph 70 and 71, page 260 to 261 of the judgment, where a further difficulty for Mr. Roberts, and the way he tried to evade the problem was to say was to go about it in two stages. To first of all reconstitute himself and say, I'm now suing derivatively. So I'm changing the capacity in which I, Mr. Mark Roberts, am suing. So that's stage one. And right, I'm now bringing a claim against the solicitors in right of the administrators, and therefore all I need to do is then adjoin the administrators to perfect that claim. Stage two, and that was held to be an improper procedural device. Nothing to do with this case, with respect. Claimants aren't trying to change the foundation on which they're suing against Pitmans. They're not trying to change the nature of the duty. All that they're saying is that we are seeking as claimants, Mr. Lawrence actually, hypothetically or contingently, to bring exactly the same claim, and I'll come back to that proposition, against the party who, it is pleaded in both claims, actually owed the duty of care, breached that duty, and caused the claimant's loss. My lords, I want to now, under point one, simply deal with some points made by my learned friend. We're still on the stage one of Mr. Justice Leggett's test, and what it means. Whether on my learned friend's original formulation creates a constitutional locus standi threshold, or whether it's on his reformulation excludes claims that the original claims that will fail on their merits. Now, let me just deal with a number of points as briefly as I can. The constitutional or locus standi or procedural defect gloss, which I don't think my learned friend entirely abandoned, should be rejected. And it should be rejected for a number of reasons, not the least because it was expressly rejected by Lady Justice Hallett, speaking for the Court of Appeal, in Nemeti. And your lordships don't need to be taken back to what her ladyship said at paragraph 28 and 29. Through a process of reasoning, which I have to confess I wasn't fully able to follow, my learned friend sought to assert that even though Lady Justice Hallett had expressly rejected Judge Cotter's gloss, somehow it had some, or could be seen to have some shadowy further existence. No, it's been rejected, and rightly rejected. And indeed, my lords, it was also rejected by Mr. Justice Leggett in Insight. And I'm not sure your lordships have looked in particular at paragraph 91, page 331 of the bundle, where Mr. Justice Leggett is considering the authorities. He considers Judge Cotter's gloss. If you're looking at paragraph 91, top of the page, where Mr. Justice Leggett says the judge held at paragraph 41, that's a reference to Judge Cotter as he then was in Nemeti at first instance. And Mr. Justice Leggett rejects him also the gloss sought to be extracted by the learned judge, Judge Cotter, in Nemeti at first instance. So, on high authority and binding authority, the gloss has been rejected. In any event, one might say it's very difficult to see what the limits of that gloss are. What is a constitutional or procedural or locus defect? I think my learned friend himself accepted that it's quite difficult to draw a bright line between that kind of defect and any other kind of defect. My lord, the second point I make concerning my learned friend's submissions is that he placed some, albeit I think at the end, rather limited reliance on certain dicta of Mr. Justice Mann in G4S. If we're still in the authorities bundle, we can shoot straight to page 348, which is where that's the authority, and in particular we're at paragraph 152, page 373, where in the context of a very learned and lengthy judgment, albeit one that the bulk of which has now been overruled by a later court, constituted by Lord Justice Dingemans and Mr Justice Pickin in the case of Rowett, which is in your lordship's bundle. Mr Justice Mann says, a paragraph 152, it seems that insufficient attention being paid to the word properly. And your lordships will read that paragraph by my learned friend, Mr Carpenter. I think my learned friend accepted that very limited weight could be given with respect to Mr Justice Mann to that paragraph. Any reliance that might be placed on it is wrong for three reasons. So just very briefly deal with them. One, Mr Justice Mann did not refer at any stage, and it appears he wasn't shown, the decision of the Court of Appeal in Nemeti, which would have made it quite clear that these procedural locker standi glosses are wrong. That's the first point. The second point is that Mr Justice Mann did not seem to understand, it wasn't, no doubt, because he didn't receive submissions on it, no criticism of the judge, I should say, that the word properly does not convey any different meaning to the words in the section. I'll come back to that. There's no difference between cannot be maintained in the section and properly, the word properly as it's found in the rule. The third point is that the observation itself is patently obiter. It does not inform the actual disposition on the claim, on the application that the learned judge was dealing with. And indeed, in fact, there's a fourth point, if I may expand my own points, which is that it appears that Mr Justice Mann's gloss, if gloss it can be described as, is even narrower than my learned friend's final position in his submissions, i.e. where he moved to the merits point that I've described. So with respect to Mr Justice Mann, paragraph 152 really takes us no further forward. The next point that I wish to address in respect of my learned friend's submissions on this first point that he founds his appeal on is the difference in the wording in section 35 and rule 19.6. Now, my learned friend pays lip service to the proposition that the rule was not intended to mean anything different to the section, notwithstanding the difference in wording. But having paid that lip service, he then proceeds to make a submission which is that the wording of the rule, which of course comes many, many years after the section was enacted in 1980, should by some kind of retrofitting infect the interpretation of the section. Now, it's the first time I've ever heard it suggested that a rule of court which was adumbrated 30 years or 29 years after, 20 years at least, after the section of an act, can somehow alter the meaning of a parliamentary legislative section. The rule and the section mean the same thing, and that has been authoritatively decided by this court on at least two occasions. I don't go to the authorities, but Merritt and Babb, paragraph 53, Lord Justice May, categorically and definitively says the rule means no more than what the section means. And Lady Justice Hallett says the same thing at paragraph 14 of Nemeti. And as your lordships know, in any event, even if one were to just simply jettison the section and concentrate on the rule, the word properly has been interpreted by Mr Justice Morton and then in the Privy Council in a way that conflicts with my learned friend's submission. So, finally, my lord, on this point, even though my learned friend appears to have abjured the procedural or constitutional gloss that finds voice in his skeleton argument, if one actually interrogates the case that has been proposed orally yesterday, one finds that in reality it remains in substance a submission that is founded on and is a variant of the Cotter gloss, if I can describe it as that, which has been rejected and which cannot be sustained for all the reasons that I have sought to advance before this court this morning. Because to say that Rule 19.63b does not extend to a case where the claim fails on its merits is no more than, I suggest, with respect, the flip side of saying that it extends only to a case where the claim will fail for procedural or constitutional reasons, and that is wrong for a host of reasons that I've sought to deploy this morning, not the least because it flatly contradicts what is said in Parkinson, and therefore your lordships should decide today, in my respectful submission, that the first stage of Mr. Justice Legate's test at para 96 is correct, and therefore the court has jurisdiction to order substitution where the claim as originally brought against D1 in my nomenclature will fail on the merits, or may fail on the merits for the reasons I've already given.
Mr. Grant, this may be the juncture at which I should ask you this question. It's one I posed to Mr. Lawrence yesterday. Does this, in effect, convert the provision that we're concerned with into a general discretion to, in effect, substitute a defendant and thereby deprive them of the defence that an action is statutory?
No, it doesn't, for this reason. Because before the discretion even arises, on Mr. Justice Legate's architecture, if I can use that phrase, as set out in paragraph 96, there are two threshold conditions that need to be surmounted by the applicant claimant seeking substitution. One is that my claim as brought against D1 will fail on the merits or contingently will fail in my case. But then vitally too, the claim as sought to be substituted is the same claim. That remains the second threshold which has to be surmounted. And I accept that because I accept that paragraph 96, and not only accept, I promote it as a correct statement of the law. And that takes me immediately, and my Lord's question is perfectly pitched, if I may say so, because it takes me immediately to the second submission that my learned friend, Mr. Carpenter, advances before this court. And that is the submission that the claim, or rather the claims in both Mr. Lawrence's and my case are not the same claim. Now let's frame that submission before I delve into it. Mr. Carpenter, in terms, accepts that the test, as the second stage of the test, as put by Mr. Justice Legate, is correct. He disputes the correctness of the first stage, and that's the burden of the submissions I've been advancing so far this morning. He accepts the second stage, that the claim as originally brought must be, quotes, the same claim as to be brought or proposed to be brought via the substitution. He goes on to say that Mr. Justice Legate's application of his own test is badly wrong, paragraph 98, and we've heard all about that. And he goes on to say that here the claims are not the same. And in order to make that submission, he is driven to make the submission, paras 45 and 52 of his skeleton. I've already referred to it early this morning in answer to a question posed by the court, that for the claims to be the same, they have to contain exactly the same pleas. Exactly the same facts have to be pleaded in the claim as substituted as the claim as originally advanced. And that, of course, leads him, as I've already explained, to the inevitable concession and the radical concession that essentially there will never be a scenario envisageable by him whereby the court can exercise the jurisdiction invested in it by the section. And as I've said, I think twice now, that is a very sound guide, we say, to the rejection by this court of a submission that would render the subsection within the Act a dead letter. Now, to simply say that the claim as brought and the claim as proposed to be brought is the same claim, in one sense, is simply to assert a conclusion. And we need to say something about the process of reasoning as to, or what process of reasoning should be deployed by this court to answer that question. By reference to what criteria should the court decide whether or not claim 2 is the same as claim 1, so to speak, as in the claim against D1 is the same against D2. Now, I'm going to address that, this second meta point of my learned friend in 4 sections. Authorities, first, I'm going to look at those very briefly. What we say the test is, second, how it applies to the present case, third, and I'm going to then deal with certain hypotheticals that were posed by the court yesterday. So, first of all, dealing with the authorities. Or rather, before I deal with the authorities, there is actually just one further point I wanted to make before I start looking at the authorities, which is really a continuation of the dead letter submission. And let's just, before we look at the authorities, just look back at the section, because that takes us back to the authorities bundle, page 8, section 35, 6b. Now, on one interpretation, which is the interpretation advanced by my learned friend, it becomes an entirely self-defeating section. Because if one looks at little b, halfway down the page, any claim, this of course is the second necessity test, any claim already made in the original action cannot be maintained by or against an existing party, i.e. here, BDP, in both cases, unless the new party is joined or substituted as plaintiff or defendant in that action. Now, the radical submission made by my learned friend is that the substitution can only be permitted so as to maintain the claim against the existing party. But that makes no sense. It's an absurdity. Because how can you have a situation where the court can only act where, in order to maintain the claim against D1, you have to substitute D1 for D2? Look at, on that analysis, D1 has ceased to be a defendant to the claim. So therefore, it must follow that the concept of claim being deployed at little b is not a concept which is irrevocably tethered to the original defendant, or indeed the original claimant, because otherwise it simply never arises. How can you maintain the claim against D1 by substituting D1 for D2 unless the concept of claim in the section and in the rule is not a concept which is irrevocably tethered to D1? But that's my learned friend's submission.
Do you submit, Mr. Grant, that because there's disjunctive wording used in this paragraph, that one can perfectly properly leave out some words to see if they describe the case which happens to come before a court?
Well,
let me give you an example
please,
which might be relevant to the present case. think you're submitting, but please correct me if I've misunderstood, that it can perfectly comprehensively be read as follows. Any claim already made in the original action cannot be maintained by an existing party unless the new party is substituted as defendant in that action.
Absolutely. They are to be read disjunctive. They envisage a variety, well, a whole host, in fact, because it's very concertine of legislative language, a whole host, in fact, probably 4 separate scenarios. Joinder of C2 keeping C1, replacement of C2 for C1, joinder of D2 keeping D1, and replacement of D2 for D1. So that's 4 separate and entirely separate scenarios. Hence the or under joined or substituted, and hence the or between plaintiff or defendant. But this is a vital point, because if my learned friend is right, not only can you never have a replacement of D1 by D2, as expressly contemplated by the section, but in fact you can never have a replacement of C1 by C2, because inevitably the claim, on his conception of the word claim, it is always a claim brought by that particular claimant against that particular defendant. And there's always going to be some violence done by a substitution. Ergo, in his worldview, as promoted by my learned friend, the section becomes, as regards substitution, an entire dead letter. But that's not right. Let me first of all, as I promised to do, turn briefly to the authorities. And for that purpose, we can look at 3 cases. We've already looked at them in different ways, so I can take this as quickly as I can. The first case is back to Parkinson. We've looked at that in the context of my learned friend's overarching submission 1. I want to look at it now in the context of overarching submission 2. Your lordships know the case, know the facts of the case, but let's see how the judge himself, Lord Justice Lloyd, with the endorsement of Lord Justices Sullivan and Sedley, approach the question of the exercise of the jurisdiction. We can look at 3 paragraphs as briefly as I can. Well, the first is paragraph 12, which my learned friend fairly read out to you yesterday, and it is notable that the Mr Justice Blackburn's decision in Eurocrete, which was endorsed by his lordship, refers 3/4 of the way down the paragraph of the quotation, that paragraph 12 of Lord Justice Lloyd's judgment, to what is the substance of who the claimant is. So we're looking already at substantiality, not the technicality, the substance. But then look at paragraph 13. There is no doubt, says my Lord Justice Lloyd, that the claim which the liquidator seeks to assert under section 212 is identical to that which he put forward in the name of the company by the original proceedings. And then look at this. The proposed amendments include no change to the allegations of duty, breach, or loss. References to the company are substituted for the word claimant, and references to section 212 is added to the text as regards relief. Otherwise, there is no change. So what the learned judge there, in my respectful submission, is doing is saying, I'm not hidebound to the conception of claim that is now being advanced by my learned friend in this court. I'm looking at the actual substance of what the case, as originally brought against by C1 in that case, was about. Duty, same. Breach, same. Loss, same. Yes, there have to be some amendments, but it doesn't mean the claim is different. That takes us to paragraph 28. Your lordships have looked at this at least 3 times. But so I'm going to take this as quickly as I can. But there again, look at, if you would, 7 lines up from the bottom of paragraph 28. Lord Justice Lloyd envisages that the substitution will require amendments to the statement of claim. No more than minimal changes necessary to the statement of case, substitution, and so on and so forth. So there will have to be some amendments to the claim. But what he is not expressly rejecting is a notion of the claim, which is the notion supported or advanced by my learned friend in his skeleton argument, that it has to be the claim brought by that particular claimant against that particular defendant. But the point is given added force if we go to paragraph 29, where his lordship accepts that the claim as brought under section 212 will engage different rules as to quantum, third line from the bottom, as to the quantum of compensation. He says, no, that's not a valid distinction. He says they're likely more favourable to the defendant. But that, whether they're favourable or not to the defendant is not the key point, we would say. It's just that his lordship is envisaging that the claim in its substituted format will involve a different conception of quantum to the claim as originally brought by the company. That's the first case.
Going back to paragraph 12 and the quotation from Justice Blackburn's judgment is quite important, because he says that it's made clear by the authorities that section 212 is procedural in nature. The true significance of the fact is that the section merely provides an alternative means in terms of procedure, enabling the company to which the defaulting director is owed to obtain recompense from the director for his breach of duty.
Quite.
So it is a matter of procedure only, whether it is brought in the name of the company or in the name of the.
My lord, the critical point that if my learned friends to succeed on this appeal, this court has to accept the proposition, which he's absolutely explicit about in his skeleton argument, that every fact must remain the same. The moment you change any facts in the second claim or the second iteration of the claim, you're out with the conception of same claim. Here, in Parkinson, originally a claim was brought by the company, and to save the claim, it had to be brought by the liquidator.
That may be.
It's a different claimant.
I'm not sure it was quite his submission, but we're not bound by that. And it seems to me that same claim can have, you plainly have to have some change set to what's needed, because by definition you are changing something.
Well, my lord, can I answer that question by just inviting this court to pick up learned friend's skeleton argument at paragraph 52, page 29 of the core bundle. I'm taking this as quickly as I can because I'm conscious of the time. This is at the heart of my learned friend's case. He says this, top of the page, paragraph 52, if the approach taken in office properties is not the right one, then it has to follow that the relevant section can only be invoked where the essential facts which have to be averred in each of the claims, of the two claims, are identical. And then this, there is no coherent intermediate position. That will exclude all situations in which is proposed to substitute one defendant for another whose basis of liability would be in any way different. Now, it's impossible to work out, how can you ever have a situation where the base of liability for D1 is not different to the base of liability for D2? But further, each of the two claims, the facts have to be identical. Now, in Parkinson, they weren't identical because claim 1 was, I, the company, have a claim against you, the administrators, and claim 2 was, I, the liquidator, have a claim against you, the administrators. It works actually both against claimants and defendants, my learned friends, proposition. But it's as, there it is in black and white, my lord. That's my learned friend accepts that to succeed, he has to adopt that radical position. In his words, there's no coherent intermediate position.
He may not be right about that.
Well, I'm coming here to argue, to respond to the claim that is brought by way of appeal by my learned friend. He is not right. He's not right about that. And in fact,
we're not bound to either black or white, are we?
Well, I'm going to explain to this court, if I may, what the test should be, because I'm going to try and assist the court with an actual test that actually is workable and which brings and actually makes sense of and gives life to a section which would otherwise become a historical curiosity of parliamentary self-defeat. Now, that's Parkinson. Let's go straight to insight. We can take this very quickly because your lordships have already spent time on it. Your lordships will recall that one of the interesting aspects of insight is that the judge below had treated it as a B case, i.e. she had treated, the master rather, had treated it as a case where insight had known that there was a distinction between the partnership and the LLP, and had intentionally sued the LLP on the basis that there'd been some kind of transfer of liability. And she rejected the application. Mr. Justice Leggett looked at the evidence very carefully and actually decided it was an A case, i.e. that the claimant's solicitors, or the claimants, had in fact believed that the LLP, for whatever bizarre reason, had actually been the party that was retained by the claimant and had actually perpetrated the wrongs. So he was therefore able, by analysis of the evidence, to say this is a case falling within limb A and category 1 of his paragraph 57, which I showed the court yesterday. But he then said, well, okay, assume I'm wrong on that and that the master below was right, and that in fact the proper analysis of the facts is that the claimant had always understood that the partnership had been the retained professional party and had committed the wrongs, but that there had been a transfer of liabilities in some shape or form to the LLP. Let's assume that. And then he said, well, would that come within B or not, having decided already that the facts came within A? So it was expressly obiter, but it was obiter in a very highly reasoned way, as one might expect, if I may say so, from his lordship. And the analysis starts at paragraph 86, page 330. I'm not going to take the court through it. Your lordships know that his lordship then analysed Nemetti, analysed Parkinson, analysed Irwin in a way which, if I may say so, provides substantial insights as to the true understanding of the rule. From that analysis, he adumbrated the rule at paragraph 96. We know that he then said, well, in fact, we're outside. B's not satisfied on my understanding of the facts, because, of course, on his understanding of the facts, the claim as brought was always a claim sought to be brought against the LLP on the basis that the LLP owed the duty of care, and therefore the substitution would change the duty of care pleaded as a duty owed by the LLP to a duty of care owed by the partnership. That is a different claim. I accept that. But he said, well, let's say I'm wrong on that. And that's where paragraph 98 comes in. And his analysis of paragraph 98 on the basis of the assumed facts, which are in truth exactly the same as the facts or the assumed facts in this case. And he held, and rightly held in my respectful submission, that on that basis the claim would be within B and that it would be the same claim. And I advance that as a correct interpretation of and working through of the rule that his lordship had himself adumbrated. And let's just briefly touch upon paragraph 114. I don't think the court's seen this before yet. Page 336 is the last paragraph of the decision, where his lordship expressly envisages that as a result of his ruling, the particular claim will have to be amended, just as was envisaged by Lord Justice Lloyd in the Parkinson case. So my learned friend's submission, which we also find expressed in his skeleton, that, because there needs to be some amendments, therefore that shows that they're not the same claim, is wrong. And of course, Master Teverson as well had envisaged that there would need to be amendments if the substitution were to take place. My lords, I go finally, and I should just say this in passing, that in this court, the paragraph, certain of the paragraphs in Mr. Justice Leggett's decision were quoted. This is Mark McLaren, Class Representatives, page 410. And there's then a consideration of the rule. And if we go straight to page 444, please. We see, this is paragraph 96 of the decision of Lord Justice, in fact, the conjoined court, comprised of Lord Justices Lewis and Green and Snowden. Paragraph 96 of that decision quotes Mr Justice Leggett's reasoning at 96 and 97 of Insight Group. Now, it's fair to say that it was decided that, in fact, the claimants were out with the rule for different reasons. But no doubt is cast by that Court of Appeal on the adumbration of the rule by Mr Justice Leggett at paragraph 96, which may be significant. Indeed is significant.
And this is Overton.
It's not. I accept it's not the Court of Appeal expressly adopting the rule and saying that represents the law of England and Wales. But it's notable that a court that might be expected, if they saw a dictum that they thought was wrong, to comment on that, quote it without any form of disapproval whatsoever. But it is open to accept that.
Since I've interrupted you anyway, Mr. Grant, can I just ask you how much longer you
Well, I am going to be a bit longer, if I may be, only because I have quite rightly been subjected to probing questions which have necessarily required a proper answer.
There may be others for you, but realistically, how long do you need?
If your lordships could give me to 12:15, then I'd be very grateful.
Yes.
Thank you very much. I'm grateful. My lords, the last.
I do stress, Mr. Grant, and this is not meant to be directed at you. It's for everyone. In this court, which being an appellate court, which creates binding precedents, advocates must expect that there will be questions, probing questions from the court.
My lord, I welcome such questioning. I hope I always welcome questioning from this court. The last decision that I wanted to briefly show the court, which again it has been shown yesterday, so I hope you can take it relatively quickly, is of course Nemeti in the Court of Appeal. Your lordships know the facts. The critical point, and this is page 337, I should say, the critical point in Nemeti, which I absolutely respectfully accept, of course I'm bound by it, but I respectfully accept that it was absolutely rightly decided, is that the two claims that were advanced, one originally sought to be advanced by way of substitution, were qualitatively different claims. The claim as originally advanced against the insurance company was a claim to a statutory remedy advanced under Regulation 3 of the European Community's Rights Against Insurers Regulations 2002. You see that at paragraph 3 at page 339. Whereas the new claim against the estate of the deceased driver was a negligence claim, so a common law claim to damages. Entirely, if I can, entirely different beasts. The one then turns to paragraph 27, please, where Insight Group is referred to by Her Ladyship, page 343, bottom of the page. No suggestion at all that Insight Group was wrongly decided or that the test was wrongly adumbrated or wrongly applied. All that we have Her Ladyship saying is to describe a submission of Mr. Palmer, bottom of page, paragraph 27. He described the test that I had advanced before your lordships as bland. Well, I don't know what that means. It's the first time I've ever heard a decision of Mr. Justice Leggett's, where in whatever court he sits, as bland. But Her Ladyship doesn't lend any support to that remarkable submission. So we have a case which is flatly on the relevant rule, is flatly deciding the question about whether or not the new claim is the same claim as the old claim, so to speak. And the test as set out by his lordship in Insight Group is quoted, and no suggestion that Mr. Justice Legger had blundered or erred. The material parts of the decision in the case start at paragraph 41, page 346 of the judgment. And what is, your lordships have read that, of course. But what is absolutely clear from those paragraphs, if I may respectfully suggest, is that the reason why the appeal failed, the reason why substitution was refused, was because Claim 1 was an entirely different juridical creature to Claim 2. And we can pick this up bottom of paragraph 1. Claim 2 was based on, Claim 1 was derived from statute. And then we can go to paragraph 42 right at the end. The original claims, the four lines from the bottom, the original claim was not therefore a claim for damages for personal injury against the respondents, contrary to Mr. Burton's insistence. It was not a claim in negligence. It was effectively a claim for an indemnity under statute, limited to the respondent's liability to their insured. Now, it's an entirely separate, if I can use this phrase, juridical creature. A claim limited to the insurer's contractual liability to the putative insured. There may have been a cap in liability. Who knows? As against the claim, the liability or the putative liability of Mr. Borough's estate for damages in negligence. But then we see that again at paragraph 43. And then paragraph 44, thus, although the late Mr. Borough's alleged negligence underlines both claims, the claims are not the same. It's not simply a matter of form. In substance, these are two different causes of action. And again, we have obtained some significant assistance with respect from that last sentence. Her ladyship is not suggesting that there is the test that needs to be adopted is the test put forward by a paragraph 52 of my learned friend's skeleton argument. It is a question of substantiality. Are, in substance, Claim 1 and Claim 2 the same? What then should the test be that this court should adopt, in my respectful submission? If we go back to Parkinson, and to a paragraph which I don't think your lordships have been shown so far, back to, it's tab 15, back to it's to paragraph 19 now, page 231. Lord Justice Lloyd in Parkinson refers to a decision of the Court of Appeal in a case called Weston and Gribben, which I'm going to show you very briefly, and suggests, and that was a case under Lim A. And he refers to the convenient working test suggested at paragraph 41 of the decision of this court in Weston and Gribben. Before we go any further, can we just keep a finger at 231 and just see what that test was as proposed by the Court of Appeal in Weston and Gribben? That takes us to page 197 of the authorities bundle. Facts, we don't need to worry about facts. And there, Lord Justice Lloyd, at the bottom of paragraph 41, refers to something that Lord Justice Sedley said in the course of argument, a convenient working test to ask whether you can change the identity of the claimant, or as the case may be the defendant, without significantly changing the claim. Seems to be a sensible working test, says Lord Justice Sedley, with the agreement of Lord Justices Lloyd and Hallett.
I'm very sorry, you're reading now from
Page 19, forgive me, I'm going very quickly. 197,
Yes.
page 197,
Yeah.
which is a paragraph in Weston and Gribben, the last 6 lines, forgive me, madam.
of 41.
So in a court constituted by Lord Justice Sedley and Lord Justice Lloyd and Lady Justice Hallett, that working test is adopted. Now, we go back to Parkinson as quickly as we can, because I'm conscious of time and not wishing to trespass on the court's patience.
So
It-
forgive me, what were they addressing in 41? Is this an A case?
It was an A case.
An A case, yeah.
Now, the in a B case, which Parkinson was, Lord Justice Lloyd at paragraph 19, page 231, refers to that test. Now, he then accepts that as a test applicable to A, that test has not survived. And it hasn't survived because the later decision of Adelson. And let's just remind ourselves, we haven't looked at Adelson, very briefly. Adelson was an A case, where your lordships will recall it was the one that refloated the Sardinia sulcus after it had been confined to the bottom by Lord Justice Jacob in an earlier case called Morgan. But if we go back to Adelson, which is at tab 14 of my Lord's bundle, and go immediately to paragraph 56, page 220. What the court in Adelson decides is that as relates to little limb A cases, Sardinia sulcis or sulcus prevails, and therefore the working test suggested in Weston and Gribben, does your lordship have right at the bottom of page 220 over the page, inasmuch as it extends wider than the Sardinia sulcus test, should not be relied upon. So Weston and Gribben is not adopted vis-a-vis limb A cases, which of course have nothing to do with the concept of same claim. That's the critical point. Limb A cases are not dealing with the same claim question. But there is no reason, in my respectful submission, why the sound instincts of a court of appeal constituted by the learned judges that I've identified does not have and should not have real assistance. And indeed, one might say it is no more than the test that was actually adopted by Lady Justice Hallett in the B case of Nemeti. So what I suggest to this court, whether one founds it on Weston and Gribben or not, is that the test to be adopted in deciding whether the same claim has been, the claims remain the same pre and post substitution, is whether the claim has been significantly changed or not. That, in truth, is the test that was actually adopted by Mr. Justice Leggett, see paragraph 98 of his judgment in Insight. It was the test that was adopted by Lady Justice Hallett and the Court of Appeal in Nemeti. I refer back to paragraph 44, which I quoted to this court, where her ladyship referred to the question, used the very phrase, just to remind this court, I don't want to misquote it, used the very phrase, in substance, these are two different causes of action. And one remembers back to Weston, does the change significantly change the claim? Significantly, substantially, I suggest those are interchangeable words. Now, that should be the test. Your lordship should reject the test proposed by my learned friend because it is unworkable for the reasons I've already adopted. We then turn to the third stage of my submissions, the present case. Here, the core allegations which found the claim, both in Mr. Lawrence's case and my case, are the same. Whether the claim is made against Pitmans or BDB Pitmans. And that breaks down into 4 propositions. 1, the same duties are relied upon, both contractual and tortious. 2, the same breaches are relied upon in pre and post substitution. 3, the same loss is relied upon, which takes us even narrower than Parkinson, which of course where the loss analysis was different in the substituted claim, but that didn't stop the Court of Appeal ordering substitution. And 4, the same proposition is relied upon, that Pitmans was liable for damages to the claimants, which is the necessary premise for the final link in the chain in both cases, which is that by some process or other, whether it's through succession of insurance or novation, that liability had transferred to the defendant, to D1 in my nomenclature. And I say, applying either the Western test of substantiality or of significance, or the Nemeti test of substantiality, and approaching the matter in the way that Mr. Justice Leggett approached it, which is no different from those 2 previous approaches proposed by the Court of Appeal, this claim, as substituted, whether in Mr. Lawrence's case actually or in my case contingently, is the same claim as the claim that was advanced against Pitmans. Now, my learned friend, Mr. Carpenter, responds by saying, well, what about all the claims about novation, estoppel, and acknowledgement? Those are doctrines that are relied upon to seek to assert liability against D1. But they are not part of the cause of action. A novation is not a cause of action, estoppel is not a cause of action, nor is acknowledgement. They are merely pleas which, if they are successful, will establish liability on the part of BDB Pitmans for Pitmans LLP's breaches of the duties it owed, which caused the claimant's loss as a result of Pitmans, the same loss and the same proposition that Pitmans are liable for the damages or the damage caused by or to the claimants. All that would occur in my case, and indeed Mr. Lawrence's case, as a result of the substitution, is the ignoral of the allegations which seek to transfer the liability. But there should be no difficulty with that, because the only basis on which those cannot be ignored is if this court adopts the radical solution proposed by my learned friend, which is that in both the first claim and the claim as substituted, every fact has to be identical. But as I have said, and I repeat for the final time, your lordships will be pleased to hear, if that was right, forgive me, in every case of a substitution, the basis of liability of D2 will necessarily have to be different to the basis of liability for D1, because they're necessarily separate legal entities. The whole conception of substitution carries with it the notion that one is initially suing entity 1, and one is seeking to substitute in place of entity 1, entity 2. Now, in the last 5 minutes, which your lordships have been kind enough to allow me, and I'm grateful again, if I may repeat that, can I just address, as briefly as I can, some of the hypotheticals that were proposed by my lords. Let's say that there's an assignment by C1 to C2 after the claim has been issued and after the cause of action, after the limitation period has elapsed. Now, on my learned friend's case, that would be outside the rule, because going back to paragraph 52, it would require the plea of different facts, because it would require the plea under the substituted claim that, in fact, C2 is now entitled to claim the loss or the debt or whatever it might be, the claims are not identical, because C2 is now seeking a remedy against the defendant. Ditto in a novation. On my learned friend's case, that would be out with the rule as well, because after the novation, the liability is passed from D1 to D2 through a novation. But no, says my learned friend, that's outside the rule as well, because you would have to plead the novation in order to bring home the liability to D2. So you're out of court there as well. What about a statutory reorganisation, which transfers by statute the liability of D1 to D2? You're out of court in my learned friend's worldview, because you'd have to plead the fact of the reorganisation, which pins liability on D2 rather than D1. Back to paragraph 52. You're out of court. Vicarious liability. My learned friend Mr Lawrence proposed an answer to, I think, what the question posed by my Lord Justice Phillips, and I endorse and agree with that answer. If C has sued D1, being the assumed employer of the employee, then the claim will have asserted Ms X, the employee, was driving in her van along the Peckham High Street and crashed into me, the claimant. She owed me a duty of care. She breached that duty. She caused me loss, and she was acting in the course of her employment, and therefore D1 is liable for her torts. So in that scenario, then within the original claim, all the constituent parts of the claim against Ms. Employee, forgive me, have been pleaded. All that's been said further is that the defendant employer or understood employer was liable. Let's assume, in fact, she wasn't employed by anyone. She was a sole trader, and it was a complete mistake that she was employed by D1. Now, the vicarious liability of D1 is not part of the cause of action. The cause of action is what I've just outlined. And if it turned out, it was discovered after the limitation period that, in fact, D1 was not her employer, or she was on a frolic of her own, let's say, then there would be jurisdiction to amend the claim to bring in the employee as D2 in place of and in substitution for the employer. I say that subject to this vital caveat, which is that if one looks at the way the courts have exercised their jurisdiction as their discretionary jurisdiction, after assuming the thresholds have been surmounted, now a discretion, then the way that discretion has often been influenced, or the exercise of that discretion has been influenced, is by reference to the connection between D1 and D2, and by reference to the fact that typically, and in these cases are paradigm examples, D2 knows all about the claim because the natural people who stand behind D1 and D2, and in this case, of course, the insurers and the solicitors and all the rest of it, are the same. And one can well see that a claim that's been running against D1, and then 3 years later, crikey, you made a massive mistake. D1 is not an employer of the employee. The employee then suddenly, out of the blue, hears about the fact that she's now purporting to be sought to be sued. One can well see that the discretion would most likely be exercised in her favour. So that's the vicarious liability angle point. The guarantee question that was posed by my Lord Justice Phillips, that would not be within the rule because by reference to the tests proposed by Lady Justice Hallett, Lord Justice Sedley, Mr Justice Leggett, they are fundamentally different claims. One is claiming against a guarantor on a contract of guarantee, as opposed to claiming against the debtor on a contract of debt or a contract of loan or whatever it may be. The instrument seeking to be enforced in each case would be different. So I dispute, and I don't think my Lord suggests others, but I accept that a claim on the guarantee would be outside of the rule. My Lords, therefore, in final conclusion, your Lordships should ask, I suggest respectfully, two questions. First, can the existing claim properly be carried on by or against BDP? On the assumption that my clients are wrong about the novation, estoppel, and acknowledgement, which was precisely the assumption which Her Ladyship made for the purpose of the declaration without any form of cavilling from the claimants, then the answer is assuming we are wrong on novation, estoppel, and acknowledgement, then the answer to that question should be no. The claim cannot be properly carried on, or in the language of the statute, maintained against BDP. So that's threshold 1. Threshold 2, can the claim made against BDP properly be carried on by Pitmans as substituted, and is it the same claim? Answer emphatically, in my respectful submission, yes. My lords, I have trespassed on your time long enough. Thank you for that indulgence. Unless I can assist the court any further, those are my submissions, and those are the reasons why this appeal should be dismissed.
I'd like to ask you about the contingent order. It may not be something which is particularly in dispute between the parties, but it does seem to me it's in our judgments, it may be something we want to think about. It seems to me that the reason why the order is made as a contingent order is because at the moment you would say your original action can be maintained, and it is being maintained.
Yes.
And the position is that what you say is if we lose the arguments of novation and stopping, etc., then at that point it cannot be maintained, and at that point we would fall within 6B.
Quite. If the arguments of principle are favourable to my client.
The contingent order being made now is that surely the point of time at which the judge or a judge has to exercise their discretion is when B is satisfied. So how could a judge make a contingent order now to come into effect at some future date, possibly months, possibly longer away, rather than the discretion being exercised at that point? Because as you say, whether or not it is right to make that order at that time may depend upon what has happened in the interim. So how can you justify a contingent order in these circumstances?
Right. There are a number of answers to that question. Answer 1 is that there was not one syllable of a suggestion by the claimants, by the defendants at the hearing before the deputy judge or at any stage prior to the hearing that was a point they advanced. They argued the substitution application as an application that could properly be determined, albeit on a contingent basis, and there was no suggestion that the court should withhold their discretion until some later stage. So, and answer 2, it is no part of my learned friend's appeal, and one can look at the grounds, one can look at the skeleton argument, one can look at the oral submissions. Remember the oral submissions. There was not one whisper of a suggestion that there was a freestanding appeal.
I understand all of that, and no doubt good points, but what's the substantive answer to my point? Do you maintain that this is a correct procedural route that we should endorse, or do you accept that it may be something we should express the view isn't the right way to proceed?
No, you shouldn't do it. The second, can I explain this? The second point is that it was an available argument, a bad argument, but an available argument to the defendant to say, look, you might want to decide the questions of principle that arise on the interpretation of Nemeti, insight, etc. But it was an argument available to say, but because of the discretionary element of forgive me, I'm gabbling. It was an available argument to the defenders to say, you can decide the questions of threshold.
I understand the defendants didn't argue the point, and I think I prefaced it
No,
by
but
saying that there's no argument between you. But what troubles me here is that the surely the judge herself, exercising her jurisdiction under this section, should have said, actually, I cannot at the moment exercise my discretion because at the moment the section hasn't been satisfied.
But that would have been a point for the defendants to say, the reason you can't exercise your discretion now, you can decide possibly the points of principle, but you should stay your hand on the discretion. They could have said you should stay your hand on the discretion because of factors A, B, and C, and let's see how things pan out. That would have been an argument, I suppose, theoretically available to the defendants, which they didn't raise. It was for them to put forward the factual basis or the arguments why a discretion should be not up.
Sorry, Mr. Drummond, I'm sorry to interrupt you.
Well, sure.
I'm partly interrupting because of time, but
Quite.
also there's actually an important point here. Forgive me, but let me make it. The parties can never confer jurisdiction on a court by consent, by failing to take a point, for example. Now this provision, everyone agrees, this provision, whatever its scope and effect is a jurisdictional provision. The discretion only exists if a case is within the court's jurisdiction.
Well, could I just make this brief point, conscious of your lordships at the time point, which is that the discretion was exercised in my client's favour. There is no challenge to that jurisdiction, to that exercise of discretion in the appeal. This is a separate point by this appeal. Now, as a matter of, I suppose the principal point is, which is whether or not a court should stay its hand. I suppose one could envisage circumstances in which the court might say, look, I'm deciding the court has jurisdiction, but I'm going to see how things pan out before I decide whether or not to exercise the discretion. But here, there were no facts that were even available to the defendant. No doubt why they didn't argue the point, because all the facts concerning solicitorial representation, the insurance position, the knowledge of the parties were all available and all known to the court. So there was no further fact that might emerge, that might influence the exercise of the discretion. So I think my answer to your lordship's question, which is a very long answer to a short question, but possibly it may be said, it is possible to envisage a scenario, I accept, where on the facts of a case such as this, the judge might decide to delay or postpone the final exercise of discretion until, say, after the preliminary issue had been decided. I can envisage those circumstances.
Surely that would be delaying it until the court actually has jurisdiction to exercise the discretion.
Well,
the section has been satisfied.
Well,
is that not right?
The court is entitled to make declarations such as the declaration that was being.
Not to exercise its jurisdiction, surely. But to exercise its discretion, because the jurisdiction to do so hasn't arisen. That's the point. I don't
think I can take the matter much further.
We understand your response to my lord's question. Can I just check with my... I'm very grateful to you.
Thank you, my lord.
Now, Mr. Carpenter, as you know, you were shorter opening the appeal than had been estimated. I hope in the interest of fairness to all concerned, I've been tolerant, particularly of the second respondent. And I will be tolerant of you if you need longer than the half hour initially envisaged. But I would certainly hope that you can finish by lunchtime. Is that possible?
My lord, I'm very grateful for your consideration. I have every intention of being done by 1 o'clock, and I hope a little time before that. There are 4 points that I propose to address by way of reply. The first is very short, and for that reason alone, I'll dispose of it now, and it relates to the comfort that the learned friend Mr. Grant says he can take from this court's judgment in the Mark McLaren case. Could we come back, please, my lords, to tab 23, page 444 in the authorities bundle, where, as my learned friend showed your lordships, the judgment of this court set out paragraphs 96 and 97. They're not paragraph 98 of the judgment in Insight Group. And then made some comment on it in what was paragraph 97 of the judgment in Mark McLaren. When considering this, it's very important, my lords, to have in mind what the Mark McLaren case was actually about, which perhaps your lordships do already, and I'm just telling your lordships what you already know. The crucial question dealt with here was whether B was open to a party where the claim was a nullity when issued because the claimant simply didn't exist. And the particular question was whether a previous decision called AIG had correctly held that you could use B in those circumstances. Now in AIG, the issue arose because there was a corporate claimant that had been dissolved, and the judge had held you could nevertheless rely on B. In Mark McLaren, the issue arose because of human claimants who had died before the proceedings were issued. But equally, claims issued in the name of a deceased claimant are nullities. What the court decided in the end was that AIG was wrong, and that you can't use B, where the proceedings issued are a nullity. But what the court did in these parts of the judgment was look at each of the cases of Parkinson, Irwin, and Insight Group and say essentially these don't help us because they don't address the problem that we're concerned with, which is the question of nullity from the outset. So the first point, and perhaps the fundamental point that I make, is nothing in paragraphs 96 and 97 of this judgment can be regarded in any way as an endorsement of what Mr Justice Leggett had said in Insight Group. Those circumstances were not something this court was concerned with at all. But subsidiary to that, I would also note that the parts of Insight Group that were referred to here were the parts that dealt with the type A circumstances that Mr Justice Leggett had in fact found. So that's what he concludes in paragraph 97. In a type A case, you are not within type B because you are alleging different facts. Nobody in this court suggests that his lordship was wrong about that. There is not even a reference to the obiter observations of Mr Justice Leggett in relation to the hypothetical type B case that wasn't in fact before him. And the final point that I take from this, which is one which I would say, if anything, helps me, which is that we see in the middle of paragraph 97 that this court in Mark McLaren quite clearly read the test that Mr Justice Leggett had set for himself as being one of identity of cause of action. Because that's what is said in the middle of paragraph 97. It wasn't within B because the claim against them was not the same cause of action. That, I think, is all I need to say about that. I move on now to something of much greater substance, which my learned friend Mr Lawrence modestly called the small gauntlet, because it's clear from my learned friend Mr Grant's submissions is rather larger than that. Indeed, it's the centrepiece in many ways of his case. And it's the point also my Lord Justice Phillips put to me yesterday, which is if you are saying, in effect, and I do still say, that you can't in reality substitute one defendant for another, how can you square that with a statute and rules which expressly provide for it? And I have two clear and firm answers, one of which explains the Act and one of which explains the rules. And the second answer also answers my Lord's questions about succession and transfer of claims after proceedings have been issued. To a large extent, the answer to both is to be found in different parts of the judgments in Roberts that we have not yet looked at. So in dealing with the Act, the explanation really lies in the legislative history. Now, I said in opening yesterday that was something I was not going to go into. But I'm going to do it now, not to make the sort of submission that was made in Nemeti, but to show very clearly why Section 35 was drafted in the broad way that it was. And we can take that from the judgment of Lord Collins, beginning at paragraph 27, tab 16, page 247. And my lords will see there at the beginning of paragraph 27, his lordship introduces the 1977 Law Reform Committee report that resulted in section 35 of the Limitation Act. Now, paragraph 28 of this judgment contains a number of examples of situations which the Law Reform Committee should result in changes of constitution of the action being permitted where they weren't presently. But I'm not going to take your lordship through those because as set out there, they're not complete. That is not the complete list. The complete list, as we'll see shortly, appears in the first instance judgment in the METI. What I will do is go on to paragraph 29. What I will simply say, by reference to 28, and I'll make good in relation to the METI, is that the Law Reform Committee identified a small number, I think 5, specific situations where it was thought that substitution or joinder of a party should be permitted. Now, what we see in paragraph 29 is that the committee recommended that the Rule Committee should be given power to cover by rule specific cases falling within a formula embodied in primary legislation. It rejected the solution of legislating for the specific cases. It accepted that the necessary formulation would not be easy, and it accepted that it had not been able to devise any entirely satisfactory formula. I think I can then go down to point 3, further down that paragraph, about 6 lines up, where one of the conclusions of the committee was said to be that the rule-making power should be enlarged so as to confer power to enable parties to be added out of time in specific cases if A, the plaintiff's action was not properly constituted unless the new party were joined, and B, the plaintiff was not seeking substantive relief against the new party, or if substantive relief was sought against the new party, joinder of the new party was necessary if the claimant's claim against the defendant was to succeed. Now, as that implies, and we will confirm in a moment in the METI, the Law Reform Committee did not envisage substitution of the defendant. The only change on the defendant's side that the Law Reform Committee envisaged was joinder in cases of joint liability where your action is not properly constituted without the joinder. And we then see, just going on into paragraph 30, the result of those recommendations was section 35 of the Limitation Act and the resultant changes to the RSC. So having set the scene, my lords, there, we can then go on to Nemeti, tab 18 of the authorities bundle, and first of all, just to give this context, page 294, paragraph 27. This is simply by way of a signpost that this is where Judge Potter begins setting out the relevant passages from Roberts in relation to the legislative history, some of which I've just shown your lordships. If we come on then to page 300, we get into the real meat of this.
We haven't addressed any of this.
So we see at paragraph 35 in the middle of page 300 that Judge Cotter refers back to the development of the provisions, and then very helpfully here, because we don't find them in Roberts, Judge Cotter says that he then went and looked at the report to identify the 5 situations which the committee said were situations for which change was needed. And I won't read all of those out, your lordships can of course perfectly well read them for yourselves, but you will note, I'm sure, that situations 1 to 4 are all concerned with changes on the plaintiff's side, and as was hinted at in Roberts by Lord Collins, only number 5 was concerned with a change on the defendant's side, and it was indeed where joinder of a jointly liable defendant was necessary to make the action properly constituted. Now, as we saw in Roberts, the crucial point about this is that the committee made, and obviously Parliament following the committee's recommendations, made a very deliberate decision to legislate more widely than anybody thought was necessary. In essence, the committee effectively modestly questioned the ambit of their own imagination and took the approach, followed by Parliament, in the primary legislation, legislate for every possibility, which my learned friend Mr Grant quite rightly says is 4 of them. Additional substitution on either claimant's side or the defendant's side. Leave the rest to the rules and the courts to work out. So that enactment was made on the face of it permitting substitution of a defendant, but at a time when nobody believed that substitution of a defendant should be permitted. Now, upon enactment, what we see in paragraph 38 of the judgment in the METI is that the the attendant rules of the Supreme Court simply reproduced the 5 situations that the Law Reform Committee had recommended. So up until the introduction of the CPR, it remained the case that although the Act said, in principle, you can substitute a defendant, you couldn't do that because the rules didn't permit you to do so. Now, that was what led Judge Cotter to conclude that Section 35 was only concerned with procedural issues. Now, the point which is rightly made against that, which is a subtly different one, and made by Lord Justice Lloyd in Irwin and made by Lady Justice Hallett in Nemeti, is that, yes, but the rules do now allow us to do anything that the Act allows us to do. And, for example, the circumstances in Parkinson and Irwin, which I don't think anyone would question now, don't fall within the 5 situations envisaged by the Law Reform Committee. So I'm not making what might be regarded as heretical submission that was made in Irwin and Nemeti. The point I'm making is that there is a clear and rational explanation for Section 35 being drafted as it is, and yet substitution of a defendant not being possible. So that's answer 1 that deals with the statute. That, of course, does not by itself answer the position in relation to the rules, because clearly whoever drafted Rule 19.6 3 clearly did think that provision in principle should be made under the rules for substitution of a defendant. Now, the perhaps slightly superficial answer could be to say, well, it's the same as the Act. Just make the rules mirror the Act, after all that is essentially the structure of the rules, and leave it to the courts to work out what you actually can and can't do. In many ways, in my submission, that is a good answer, given that we know it is the approach that was taken under the Act. But there is another possible explanation, which we also get from Roberts, in which also lies the answer to the post-issue transfer question. And for this, we have to look at part of the judgment of Lord Walker in Roberts, at page, beginning relevantly here, page 269, tab 16, and paragraph 104. And the clearest answer to the post-issue transmission question is in the first sentence of paragraph 104 of Lord Walker's judgment in Roberts. He says there, in the ordinary case of a simple assignment or transmission of a cause of action after proceedings have been commenced, no question of limitation arises. And that is the decision, or that comes from Lord Justice Millett's judgment, as he then was in the Yorkshire Regional Health Authority case. And he goes on to say further down that paragraph, he has no doubt that the Court of Appeal was right in that conclusion, though he didn't fully understand all of the reasoning. Now, the Yorkshire Regional Health Authority case was precisely the sort of case that my Lord Justice Singh was referring to yesterday, where an NHS reorganisation meant that one body had ceased to exist, another had sprung up in its place, and by statute, everything in Body 1 had been transferred to Body 2. That was actually a case in which the YRHA was the claimant, but it had quite properly issued proceedings, but post-issue of proceedings, suddenly it no longer exists. There is a new body that can proceed with the claim. The ratio of that case is that in those circumstances, it's just not a limitation question. You're not within Section 35. Section 35 has nothing to say about that situation.
Leaving aside authority, what's the principal answer why it's not a limitation? There could be 2 scenarios. One is that the assignment or transmission, let's say by statute, has occurred during the limitation. So you sue D1, but D1's liabilities, etc., are transferred to D2. possibly because D1 no longer exists, or possibly because there's simply been a reorganisation of functions. That can happen in local authority
Yes.
situations.
Yes.
But in either of those situations, you could have that you now want to sue D2, but it's still within the limitation period. And I can well understand there, no question of limitation arises. But suppose you want to sue D2 and the limitation period has expired. And you know, why doesn't Section 35 in principle have anything to say?
Well, that's what this is directed at. Of course, we don't have the Yorkshire Regional Health Authority case before us. But if your lordship's question is, are we really talking about post-limitation situations? Then yes, we'll see that where I was going to go next, which is over the page. Because what is also clear is that before that decision in 1996, there was some uncertainty about the position. So we see in paragraph 105 over the page, his lordship says, in that case, Millerton Evans LJJ referred to the impressive and penetrating and scholarly judgment of Mant J and the Choco Star, to which I've already referred briefly. The Choco Star seems to be the first case in which it was necessary, because of the wrong turn taken in another case, Top Rack Energy Sinai, to consider whether the transmission of the pending cause of action had implications under the Limitation Act. Previously, it seems to have been assumed that there were no such limitations. Mant J analysed the position and spelled out why that assumption was correct. So we then see in paragraph 106, these are dicta of Mant J as he then was taken from that case of Choco Star, which was apparently concerned with exactly the sort of situation I think my Lord Justice Phillips was putting to the bar yesterday, where foreign law will cause issues of succession, and it then says he then explained just under D why there was no problem under the Limitation Act. In all such situations of which death is only the most striking, it seems self-evident that any existing proceedings, but these are crucial words, properly constituted within the limitation period, should be allowed to continue for or against the party to whom the relevant right or obligation has been transferred in law, and that this should be permitted whether the transfer occurs before or after the expiry of the limitation period. And then goes on to say that was approved and followed in the YRHA case.
But under what rule, if any rule is required, does that happen?
Well, my lord, I have to confess, I have not myself read.
So in
Choco Star.
19.6c, there's reference to liabilities being transferred because of death or bankruptcy. In the notes in the White Book, it suggested that that is an example of B. And it said that because there's no separate provision made for death or bankruptcy in section 35, so the only place it could fit is in B. If that's right, if that's right, it suggests that the legislative or rule basis for this is indeed B.
Well, my lord, that is exactly where I was going to go next, if I may. Before I go there, I just do stress the importance of those words properly constituted within the limitation period, and I'll come back to that so we can see exactly where the line is drawn. So can we please, if we're using hard copies, keep a finger here and just go back, because so my Lord Justice Zacaroli has mentioned it, but it's helpful to look at it. If we go back to tab 4, page 12, and rule 19.6, we do indeed, as my Lord says, we see C there as a separate provision from A and B. Now, obviously, if what I've just shown the court is right, C shouldn't be there at all. There's just no need for it. It's got no business being in a rule that's concerned with the application of section 35. That oddity was noted by Lord Walker. So at the bottom of page 269, coming back to Roberts, and at the end of paragraph 104, a few lines up, Lord Walker says, possibly the draftsman of the civil procedure rules felt some residual doubt about the position because CPR Rule 19.53C has added to the post-expiry code a new provision which covers some but not all cases of transmission of a cause of action or liability. And he calls it an oddity. And of course, on that understanding of the law, it is. So in my submission, it really boils down to this. Firstly, quite obviously, we do not have a perfectly drafted and coherent set of rules. That much is, I submit, pretty clear. The substantive law following the YRHA case must be taken to be that where the action is properly constituted at the moment of issue, succession on either side post-expiry of the limitation period is just not within section 35 at all. That does not raise a limitation question. But it is entirely possible that the drafter of the rules, nevertheless, as they over-provided in C for death and bankruptcy, considered that those cases were actually within B. And that is therefore a coherent explanation for B independently, for B to continue to provide for that possibility. It may, in fact, as a matter of substantive law, not be necessary, but in case there's any doubt about it, here is the power that allows you to do that.
But
So,
if that is we'll have to look at the Yorkshire case because that's a Court of Appeal case that binds this court. But if it is at least a possible way of reading paragraph B in section 35, subsection 6, that it permits substitution of a defendant in that kind of case,
yes.
that, it might be said, assists your argument, because that at least means that the court can contemplate a situation in which that limb of the subsection does have some residual utility, whereas the other side say, on your submission, there's never a case in which a substituted defendant can be put in place.
Yes, my lord, that's exactly the submission that I make. There is a coherent and rational explanation for why...
I hadn't understood that was your submission. So you do now make it.
So, my lord, when... Yes, I'm sorry if I've been unclear. So when I say there can be no substitution of a defendant, I am considering the situation where the claim is not properly constituted when issued. That is what that's the essence of the YRHA decision. Section 35 is directed at the constitution of the claim when issued. If you've just gone after the wrong defendant when you issued, and by the time you realise your mistake, the limitation period has expired, that is where I say actually substitution of the defendant is not possible. This particular doctrine is one which is very clearly limited to a properly constituted case within the limitation period when issued, and subsequently you need to change the parties because there is some form of concession.
That comes from wording in the YHA decision, which we haven't seen, so we're going to have to look at that.
Yes,
We're in some difficulty in following up on that because we haven't got a decision. But let me just put this point, that if it's right on your alternative explanation that a case of death or bankruptcy is an example of what falls within B, then you do have a case of substitution of a defendant. Now, that might be said to help you in one sense, but it might be said to be contrary to your case in another sense, in that then you have a case where the claim against the new defendant is not the same claim on your case as the claim against the original defendant, because the defendant's changed. It's no longer a claim against A, it's a claim against B, which in your case is critical, isn't it?
Well, my lord, if it's put that way, I would submit that there is a distinction between transfers of liability by pure operation of law, which is what, of course, the bankruptcy and the death situations are, or under statute, or whatever it might be, and ones which depend on the acts of the parties which would have to be pleaded and proved in order to make good your case. My Lord, it's obviously an important point. I've spent quite a lot of time on it, and I should, I think, move on to my final 2 points,
Yes.
which are shorter.
Given any notice?
The next point I need to deal with is the question of the merits in paragraph 28 of Parkinson Engineering. I'm quite happy to say that I put my case in terms that section 35 excludes, or section B at any rate, excludes any case where the problem is its substantive merits, which I don't accept as a change of position. It's simply perhaps defining negatively rather than defining positively. But the submission my learned friend Mr Grant makes about paragraph 28 of Parkinson Engineering amounts to saying that Lord Justice Lloyd didn't know what he was saying when he said, well, section 212 means, sorry, section 20 of the Insolvency Act means there can't be a determination on the merits. But of course his lordship was right about that. And he's right in my submission because what is meant by the merits is everything that you would have to prove to make the defendant liable to the claimant. And a section 20 defence is therefore not an issue of the merits. It operates wholly independently of whether any aspect of the claim that you might want to make against the administrators is good or bad. It is a statutory bar in lim to the entire claim. It requires no further inquiry. There's nothing to determine. It goes to nothing which the claimant would otherwise have to prove to make good their claim. By contrast, the defence which my client pleads to the claim in Lee may be a good one or it may be a bad one. But whatever it is, determining it will be part of substantively determining the claim. It is no different qualitatively from saying I have an absolute defence because I owed you no duty of care. That, of course, was the situation in Roberts, and the straightforward answer to substitution in Roberts is, well, no, nothing is necessary for that claim to be determined. It's just a bad claim. I absolutely agree with my learned friend that there shouldn't be any sort of merits threshold. It would be entirely unprincipled for whether a claim comes within B or not to depend on exactly how bad it is on the merits, whether it's capable of summary determination or has to be determined at trial, or whether an application for summary judgment is in fact made, even if it's thoroughly bad, but the defendant's nevertheless happy to take it to trial. But in all of those situations, if the claim fails, when it fails, and it doesn't matter when it fails, it will have failed on its substantive merits. So if our summary judgment application had succeeded in Lee, that wouldn't have changed the situation qualitatively at all. The claim would still have failed on its merits, but nothing would have been necessary to get to that determination. That determination would have been made. As it is now, those issues will go to trial. Nothing is necessary for a determination on the merits of those issues to be made. And then finally, my lords, in the 5 minutes I have left, I just want to address the distinction between the outcomes in Type 1 and Type 2 cases as distinguished in paragraph 57 of Insight Group, which my learned friend Mr Grant yesterday called irrational, incoherent and preposterous. That is, of course, a distinction which derives from this court's decision in Adelson by virtue of its construction of A. These cases before the court are simply examples of claimants misidentifying the correct defendant. In other words, wrongly believing that liability could attach to the entity which they chose to sue. And the real question, if we're looking at unjustifiable distinctions in my submission, is why these cases should be within B, when all other cases of misidentification of the defendant are not. Now, in the end, the answer which my learned friends are forced to give to the question about, for example, vicarious liability is that if these cases are within the provision, then, as my learned friend Mr Grant candidly says, well then yes, vicarious liability is also within that provision. In my submission though, the guarantee cases would also have to be within it on the same logic, because to sue somebody who has guaranteed the liability of X, you must establish the liability of X. There's no sensible distinction.
But there the claim is juridically different. It's a claim under a contract of guarantee, not a claim under the principal debt.
Well, that, my lord, I would say is to make the mistake with respect of using the label rather than focusing on the course of action and the facts which have to be proved. But the answer that both my learned friend Mr Lawrence and Mr Grant gave to that question is effectively, as long as the liability you want to establish post-substitution is sort of a subset. If the smaller claim is a sort of perfect subset of the larger claim, then you're okay. But that is also going to be true in my submission of the guarantor and primary obligor cases, and it's going to be true of the vicarious.
Let's suppose, contrary to that submission, that you're wrong about that. You would still be maintaining your submission about vicarious liability.
Yes, I mean, that in my submission is really the situation which so clearly tests my learned friend's cases to destruction, because I do maintain the submission that those situations simply cannot be within the provision. Firstly, because one's instinct has to be that they're just not the same claim. But to put it more precisely in terms of the wording of the statute and the rule, there is simply nothing that is necessary for those claims to come to a determination on their merits. There's nothing wrong with the claim in which you assert that A is vicariously liable to B, except that you may be wrong about whether A is vicariously liable for B.
Because, for example, it's in fact an independent contractor, or they want an authority of their own.
Yeah.
So you would say that your problem is that you've got your case wrong.
Yes.
Not that it comes within this jurisdiction.
And that's really, although it is concerned with A, the thrust of Hamilton is, the default position, if you just got the wrong defendant, you're not within this.
And putting it the other way round, your positive submission from the very outset of your opening the appeal has been that we must never forget that statute has given a defence to the defendant. So in the vicarious liability scenario, let's say it is an independent contractor, they haven't been sued, and no one tries to sue them until after the limitation period against them has expired.
Yes, and my learned friends say, well, that's all right, because discretion will protect them. But of course, my lord has put the contrary proposition several times, and it won't be improved by my repeating it. So, my lords, I think unless there's anything I can assist with on exactly 1 o'clock,
That's very helpful.
those are my submissions.
My lords, I'm rising, and nothing, no less welcome sight at 1 o'clock, but I'm rising ready to make an offer.
Yes.
Make a gentle apology on behalf of the bar, I think, and to make an offer. My learned friend, for reasons I entirely understand, has taken some points in his reply, which are perhaps, could be said, not pure reply points. In particular, he's drawn the court's attention indirectly to some material in the Law Committee's report from 1977. That led us to a short discussion of the Yorkshire Health Authority case, which is not present before the court, which I certainly haven't read. And then we were taken to another case containing a judgment from Lord Nance, which is not before the court. And I reminded myself that yesterday, my learned friend quite correctly said that those of the bar council had not thought it necessary or appropriate to put before the court the law committee, the relevant law committee report. And I also remind myself that the court has been shown the passage in Irwin. I needn't ask the court to turn it up. There's a passage in Irwin at page 283 in which Lord Justice Lloyd said in relation to subparagraph B, this is a new subparagraph, it doesn't mirror the RSC, the court will just take it as it is and will not be assisted by material in the law committee reports or elsewhere. So I rise simply to note those points. we've been hearing some points that might have been developed, as it were, in chief, but we've heard them in reply. Council may wish, unless we are told not to, may wish to seek to provide the court with some further assistance in writing, not orally, in respect of the content of law committee reports that may be relevant to what has just been discussed, and also possibly in respect to the Yorkshire Health Authority case, which is not before the court, that may contain something of some relevance. So unless counsel are told by the court, which I hope we won't be, that would be wholly unwelcome and should not take place. For my part, I will at least consider that material to see if there's anything in it that I think the court should see.
Yes. Mr. Grant, do you have anything to say on this issue?
Well, I'm entirely the court's hands.
Yes, I'm grateful to all concerned. What we will direct is that if so advised, and not necessarily encourage it, but if so advised, then the respondent shall have the liberty to file and serve brief, and I do emphasise brief written submissions, attaching any relevant materials, such as the Law Reform Committee report, extract, and the Yorkshire Health Authority judgment. We need to have, and I'll give the appellant the liberty to respond to that.
Indeed.
If so advised. Now we want it to be a fairly tight but realistic timetable. I'm envisaging all submissions being with us within 7 days.
I was thinking 7 days, my lord, if that's satisfactory.
No, I was thinking all submissions.
Indeed, so our submissions, if so advised, and it may be that we look at the stuff and decide it's
I
not.
was envisaging
not resistance.
early next week.
Early next week, by Tuesday, close on Tuesday next week.
Close on Tuesday for you, and close on Thursday for you.
Certainly.
That's what we will direct. Is there anything else before I close the?
Nothing from me, my lord, no, thank you.
All that remains for me to say then, very importantly, is that we thank all concerned, not only the advocates from whom we've heard, because we're very conscious that others, including counsel and solicitors, have done a lot of work in preparing this case. We will reserve our judgments. Drafts will be circulated in due course to those counsel and solicitors whose details were supplied before the hearing, so they can draw our attention to any typographical or minor factual errors and agree a draft order so far as possible. If they cannot, we give liberty to file brief written submissions at that stage, so that an order can be finalised at the same time as hand down. And may I also remind the parties, particularly for the benefit of those who may not be familiar with the procedures of this court, that this court has in recent years, including in the Counsel General for Wales case, made it absolutely clear that the breach of the confidentiality embargo on the draft judgments will be taken extremely seriously by this court. Thank you all very much.
Court rise of April